learning how to draft your orders by reading. Right? So when you see this, there are wide variation. Some common things I can tell you. One is the officers who like to write lengthy orders. 20 pages, 20 pages. It impresses the bosses. This fellow has done so much of work. But you will find his findings are 3/4 of it is just a repetition of the so-called orders, which is wasteful both for taxpayer to read and for department review section to read also. The other extreme is very curt. So, again, one of the panelists mentioned, how do I dismiss all the case law that the consultant has produced before me? None of these are pertinent to this in this case. One line. None of these case law is pertinent. I therefore proceed to decide. So that's not a speaking order. You have to distinguish. You have to give reasons why you are distinguished. We are also talking about judicial discipline. Again, that was one of the points mentioned. There is a High Court order. Madras High Court has passed an order in that case. Then you have to look at it. You have to distinguish. If you can't distinguish, that's almost contempt of court. We are going against the jurisdictional High Court order. So keep this in mind that it's not, length alone is not a quality of a proof of good quality. Neither is being short and sweet. You have to find a way of doing it. And one of the best ways, especially for some of the youngsters who are here, when you start adjudicating, please write out your own orders. I teach at NACN, this is what I teach to the youngsters. At least once you start writing your own orders, then your reasoning works. If you start, earlier days somebody else would write the order, I'm not going into that. But nowadays, cut and paste. Cut and paste is very useful. Cut and paste also leads to what? No logical thinking. I find one paragraph from somewhere, I find another paragraph, and today, this artificial intelligence makes it even easier. It can write the order original for you. How do you judge? Please don't fall into that trap. Especially, I'm saying this for the officers who have commenced adjudication at this stage. Please look at how do you write. If you are a writer, not necessarily of orders in original, you have to write, you have to correct, you have to redraft, then you come to a good piece. I was reminded of this just last week when the government counsel appearing in the case against Mr. Arvind Kejriwal said investigation is an art. The court also found it quite strange. Investigation is an art. Order in original is a piece of art. It's an original piece of art. It reflects what you think, how do you express what you think. There's no point in saying, sir, I'm a very good painter, but my paintings I can't show you because they look quite bad. It is not your talent, hidden talent, your knowledge alone that matters, but how do you express it. Yesterday, the assistant professor who spoke said that she believes there are only two pillars of natural justice. I believe there is a third one. And the third one is how do you draft your order in original. The first two, even if you follow, if it is not reflected in your order in original, you lose the case. So some points were said that somebody said, I don't want a personal hearing. I think one of the lady officers mentioned it yesterday. But she said it is because the taxpayer was convinced that you have no case. A qualified statement that I don't want hearing because my case is strong. You can't accept that.
But sir, to add a point on what you are articulating, the words used in the GST law is that if there is a written request for a personal hearing or any order prejudiced to the taxpayer is contemplated, it's only suggestive, a hearing has to be given. So the courts, at least in 3 or 4 cases, have consecutively held, even though the taxpayer, while submitting reply to the show cause notice, did not ask for a specific personal hearing, but you are incumbent or responsible to give an hearing if you are going to decide against him. Even at that point of time, you need to give an hearing. Otherwise, like what you said, sir, justice is not only to be done, it should be manifestly done. Give an hearing to him. Even though you may have a prima facie view, you're going to decide prejudice to him, still a hearing.
I'm not talking of any particular person, but I had quite a senior officer who is to pass hundreds of orders without a hearing. On the ground that, sir, I'm passing it in favor of the party. So why should I give a hearing? He wants a hearing. How do he wants a hearing? Because his counsel wants his fees. That's also a fact. But the point is that tomorrow, if the department goes on appeal against his order, they will go and say, sir, I was not given an opportunity to put my facts. So again, it's a waste of time and effort on both the taxpayer's time and your time. It only keeps coming back. Natural justice denied means order keeps coming back to you. So you are doubling your work. And with so many demands, so many orders, I think you're wasting your time and your boss's time also, because the boss has to review the order. Just now we were discussing how many orders is being refund orders, how many are being reviewed. 100%. Why? Nobody has the time, nor do you have the manpower to do it. So we probably need to look at how to cut short this review. Do some risk assessment there also. Should I look at every trivial case or should I look at the major cases? By looking at every case, I am losing sight of the major cases. I'll give you an example. For those of you who are from customs, SVP, every fellow who declares that he is related, SVP circular. And SVP unit does not have the time to study all those properly. The end result is nothing productive. So last year I had recommended that we raise that minimum limit of cases above which only it will be referred to SVP. Otherwise, let the appraising group decide. Because otherwise we are not achieving anything. So these are some of the practical issues. Why do you say it should be a speaking order? It's not because the law alone says it, but there are umpteen number of High Court, Supreme Court judgments that say that your order should be a speaking order. Otherwise, we'll end up with allegations of non-application of mind. I still remember a very nice line I read in a Commissioner Appeals order way back, so I can quote it now, where he said the Assistant Commissioner has not applied his mind, comma, if he has one. I found that quite amusing. I pity that Assistant Commissioner, of course. That's another point which I will be coming to, but since I raised this, I remembered this. Please do not pass comments on investigation is improper, officers have not applied their mind. Some of us reach that level where we can pass such comments. Be objective. You are not that perfect. None of us are perfect. So even when it goes to tribunal, sometimes you find some orders which are quite critical of the lower level officers. I do not sympathize with that. If you find that his order is not logical, his order is against the law, say so. But you need not comment on his capabilities, on his failure, incapability, or whatever you call it. Keep these in mind. Sometimes, as someone mentioned during this morning's session, adjudicating officers quite often change. So you have booked the case, You have investigated, you have issued show cause notice. By the time it comes to adjudication, somebody else is in charge, right? And he is going to pass an order. So he should not sit on judgment on you. That's not his job. If he feels that there is no case, go ahead and drop it. I'm deviating from my prepared PowerPoint, doesn't matter. In Bangalore, when I came long time back, I realized one thing. We had the highest number of refund claims pending in the country in service tax. Hundreds, thousands of them. And sometimes you tell that AC to pass the order. You will pass hundreds of orders without a speaking order. So I ask you why. Sir, I am giving a refund, what is the problem? The point that one of them asked me, and I agreed with you, is that when you are giving a refund, your reasoning should be more logical than when you are not giving it. Right? You should be convinced that you are giving it correctly. During the Viva that I had, one of the officers came and I asked him, what is your achievement in the last 2 years? What have you done? He said, I have given so many crores of refund. And I asked him under which section, how, where. He was fumbling. I said, you are risking your career. Put it down in writing. Why are you doing this? It's not that only contrary orders should be well given. Even orders which are in favor of taxpayers should be well given. That is why we call it a speaking order. Okay? Now, the department wants to review your orders, the taxpayer wants to study your orders, so both should have equal opportunity. How do you do that? By giving both sides of the picture, don't leave it to only one. That is why reasoning, supremacy of reasoning is there. It's always reasoning that supports the decision. I am just quoting some lines from some orders of the courts. Failure to give reasons amount to denial of justice. This applies in all situations. Link between the mind of the decision maker and the controversy in question. A reviewing authority or a taxpayer cannot delve into the recesses of your mind to find out what this man was thinking. Even we can't find out from within our own family, right? What my son is thinking or my wife is thinking. I don't know. So don't do that. Leave it to him to delve into your mind. Sir, this is what I meant. And it's not, we're not only talking of demands. We're not talking only of GST. Natural justice applies in all orders you pass. For instance, you cancel the license of a customs broker. You suspend the license of a customs broker. You suspend an officer. You pass an order under conduct rules. All these principles apply. Nowhere is it said that it will apply only in tax matters. It applies to all matters because it's one of the fundamentals of rule of law. Today everybody talks of constitution. All members of parliament are working on the copy of constitution. I don't know in our own office you will find a copy of the constitution. I think you should also see it. Reason is the heartbeat of every conclusion, and without the same it becomes lifeless. So everything should have a reason, and that reason should be apparent on the record. It should not be something that is hidden somewhere. Now, in one of the decisions, the present Chief Justice, Justice Chandrachud, has gone into the use of language. By not necessarily, he has spoken about use of language by the judges, the judiciary. But I think it equally applies to you, equally applies to all of us. And some of it I have given here. In fact, he commented on the High Court decision. He says, the court in appeal found it difficult to navigate the maze of incomprehensible language in the decision of the High Court. The High Court order has so incomprehensible that they couldn't understand. So, look at it from the citizen's point of view, the taxpayer's point of view. Can they understand what you have written? Probably the officers who are reviewing the order may be more qualified, more experienced because you are doing that on a day-to-day basis. But a taxpayer who suddenly receives an order from you probably has to go running to some lawyer because he cannot understand what you are trying to do. And very often we use language to scare people. Part of the reason why this fear of tax department is the use of language. An example I'll give you. If a post parcel comes carrying a $10 note, you should see the notice which is sent to an individual. A couple of them have come running in the morning to me, sir, will I get arrested? It starts with so and so section of FEMA, RBI guidelines, why no action should be taken against you? Finally, I read it, I said, it's $10, you have to get him to keep it, forget it. But the fear they put into the mind by using such language is what is something that we should overcome. Today we are talking about a more tax-friendly approach. For the first time, I think both the state and central governments really went out to talk to industry, outreach programs, was in the context of GST, which most of you are dealing with. Our department was known for never opening its mouth. But in 2016-17, I think we went to every district, we went to every chamber of commerce. Why? Because we wanted to project a taxpayer-friendly image. So every office is considered to be a help center, right? So when you pass an order also, think of how the other person is affected by your order. Does he understand? There are many things that he had mentioned, for instance, if somebody pays in advance, he pays less penalty. We used to, in customs, for instance, call the fellow and say, please go to the settlement commission. We know you are guilty. Many of them used to go. And they used to say, sir, the only reason we contested is because you will put 100% penalty. The moment they pay up in settlement commission, we close the case, government gets its revenue. Look at it from that point of view. Litigation for 10 years is not productive for either side. Language defeats the purpose of judicial writing. So, this order, in fact, if you can read it sometime, please do. The purpose of judicial writing is not to confuse or confound the reader behind the veneer of complex language. The reasoning should be intelligible, logical, and all conclusions should be supported by reasons duly recorded and specific. So the last sentence is what I was saying, writing judgments is an art, though it involves skillful application of law and logic. So what are you doing in your order? You are trying to explain how you came to that conclusion. Very often, we come to the conclusion first and then try to find some reason to come to that. I have already made up my mind, this fellow is a crook, I am going to penalize him, I am going to demand a maximum duty. And then you start searching, how do I write this? Not the other way around. You should start with the assumption that there is no case against him and then come to a conclusion. We don't do that. That is revenue bias. Okay. I'm not saying that all of you need to be heroes and go against the system. You don't have to. But you have to see a case which has got no basis at all. Now, he gave you an example of a recent service tax issue of secondment. So each case you have to apply your mind. You can't say that, okay, similar parallel we had sometime back in Central Excise, the Fiat case, where the court held that the declared value is less than the production cost. But then everybody started opening cases, so the board itself had to issue a circular that please go slow. Please read, please see each case by itself. Examine it. Don't jump to a conclusion that this fellow is definitely guilty.